Brian, we were chatting before we got started, and you learned that there would be an announcement today about the closing argument competition. You have any reaction to that for the students today?
I do. I encourage all of you to do it, even if you know sitting here that you don't want to be a trial lawyer. I mean, take advantage of law school. There's nothing lost to try a closing argument, because, you know, if you're like me, you don't know completely at this point what you want to do in your law practice. You may, and that's fine if you do as well, but try those things that the law school gives you an opportunity. I did closing argument competition and enjoyed it. I think I knew in law school I wanted to be a litigator, so it was natural for me to want to do it. But even if you think you want to be a transactional lawyer and never step in a courtroom, I would recommend that you try things like closing arguments, moot court, and all the things law school lets you do.
Well, you told me again this morning that I could ask you anything, whether I had warned you or not.
You can.
All right. So I didn't tell you that I was thinking about asking you anything about law school, but I want to ask you about your time at the University of Georgia, and if you wouldn't mind beginning with the story you told me just before we sat down about Professor Sintel and his 3 rules. Now, he's a legend,
Right.
In the state of Georgia, and I love these 3 rules. I'm going to steal them and use them in the future. But tell them about Professor Sintel's 3 rules, and then anything else about law school that has made a difference.
Okay. And I was very fortunate at the University of Georgia to be in Professor Sintel's first year torts class, and he truly is a legend. But Professor Sintel told us on the first day of class, if you're not prepared, don't come. If you're not on time, don't come. Rule number 3, always come to class. So, and he meant it. If you showed up at 8:30 and 1 second late, you didn't come in. And it took a few classmates showing up at 8:32 and endeavoring to walk in the back of the class, and the professor having to stop what he was doing to make us all understand he meant what he said. But, you know, Professor Sintel truly was a legend. He loved us, and it was obvious he loved us as his students and cared about our success. But he wasn't doing that just because he wanted some reputation to be difficult. He understood that as blooming professionals, we were going to be presented with situations where that was the expectation. And so we might as well learn from day one in law school that, for instance, applicable to a lot I do in federal court. And when a federal judge says to be there at 9:30 for a hearing, in fact, in the Southern District of Georgia, federal judge says be there at 9:30, that means 9:15. You should be there at 9:15, and otherwise you're late. But those are just lessons that it's better to learn sooner rather than later. And look, law school teaches you to think like a lawyer, but law school also gives you certain skills that are going to prepare you for law practice. Certainly, my view of the world is the primary purpose of law school is to teach you how to analyze and think and apply yourself the way that law practice requires. But you're also learning skills about professionalism and how you conduct yourself with others and the legal system and court and adversaries that are going to serve you well.
Well, tell us about that first job out of law school.
Well, my first job out of law school was as an associate with Jones Cork here in Macon. My practice has always been in Macon. And
by the way, where did you grow up? You went to Georgia Southern.
Where did you grew up in Dublin. Okay. So I don't know if we have any Lawrence County natives here, but Dublin's my hometown. So I went to undergrad at Georgia Southern, and then after Georgia Southern went to law school at University of Georgia. During both years of law school, I clerked with Jones Cork here in town, which I assume you all know is one of the larger firms here.
It's been around since 1860 something.
Yeah, right around just after the Civil War, around the Civil War. But and it's had a long and storied existence as a law firm. But I clerked both summers with Jones Cork, and actually Jones Cork recommended at the time that you clerk your full summer after your first year, and you split the next summer with a different law firm. I had such a great experience with them my first summer that I said to them, I'm happy to split, but I want to come back and work all the second summer, and I'm going to come work for you all if that option's on the table. So I started with Jones Cork as an associate in 2000 and ended up being at Jones Cork the first time, which I'll tell you about, but from 2000 to 2007.
And what kind of work did you do as a new associate at Jones Cork?
Well, like any new associate, you're going to do what the partners need you to do. That's the inherent part of being an associate at a law firm. Jones Cork has historically been an insurance defense firm, a business litigation firm, and did no criminal defense, which is now part of my practice. But so I started off my career primarily as an insurance defense lawyer. So I was at Jones Cork originally from 2000 to 2007. So progressed from being an associate to being a partner at Jones Cork.
This is a question I ask anybody who has been on that track. How do you succeed as an associate at an old established law firm like that? What does that mean?
Well, particularly as a young lawyer, as an associate, I think you succeed by being able to understand what you're there to do. And as a young associate, you're there to provide the support role for a partner, typically, in a law firm. And you're also there to have that partner have a comfort level that if I give this assignment to Brian Jarrard, within the parameters of that assignment, it's going to be returned to me in a way that I don't have to redo that effort. I mean, even now, as a sole practitioner, I use other lawyers, but the benefit of having other lawyers, particularly associates, is the ability to hand off to that individual something that they can handle, and then thus you don't have to handle. I think anybody that tells you about management would tell you that the most effective managers focus on, I'm going to do in this organization what only I can do, and I'm going to delegate to others to do what they can do. And that's how you effectively run, and that applies to a law firm. So I think the way you're the best associate is you fully understand and appreciate I'm here in a support role to make what this partner is doing for the client most efficient. I mean, look, you're billed out at a lower rate, okay, so you're helping the client. If there are things that you can do at $110 an hour that the partner would be billing the client $300 an hour for, then the client's going to appreciate you doing the work.
Yeah, I've heard some lawyers describe it as making sure as a young associate you focus on value added, right, that you actually are contributing something that the partner needs.
And that's not just the associate. I agree with that. I mean, the partner is focused on that. When I became a partner at Jones Cork, I was very mindful, as I am now, but mindful of my client doesn't need to pay me $250 an hour, or whatever the rate would have been, to do work that an associate can do and needs to be doing in order to learn how to draft a summary judgment motion and argue at the Court of Appeals. I mean, there are certain things associates are fully capable of doing that you're all going to graduate from this law school capable of doing.
What do you like about that phase of your career? Because you left it, and I'm going to ask you what you didn't like.
Sure. Well, there's a lot of comfort in being in a law firm, particularly a young lawyer. And I'll add to this now, you can get this same level of comfort if you hang your shingle right out of Mercer Law School, and I'll explain to you how you can. But to have, if you're in that life stage where you're starting a family and you're trying to figure out law practice, to have a big supportive law firm with, like at Jones Cork, there were 25 lawyers, okay? So there's not a single problem that I encountered that I wasn't able to step down the hall and ask either a more senior associate or ask a partner saying, hey, I'm dealing with this issue with another lawyer, or I'm dealing with this legal issue that I've never seen before. And so it's great to be able to step across the hall and tap into those resources without every time going back and reinventing the wheel and trying to figure out how you draft up a 6.5 certificate about discovery or something, you know.
All right, so you spend these years succeeding as an associate, you win the brass ring, you're a partner in a law firm, and you left.
Right. Well, let me first tell you, I think that they'd benefit if I give you in summary my career.
Good.
Okay. So I started practicing law in 2000. I was at Jones Cork from 2000 to 2007. In 2007, I left to become a federal public defender for the Middle District of Georgia. And the Middle District of Georgia had just opened a federal defender's office, so I helped open that office.
Explain to them what a federal defender is.
Okay. You probably have heard, if nothing else, and I heard one of the speakers earlier say she's a public defender who works at the public defender's office. Well, in this country, rightfully so, indigent individuals accused of crime are entitled to appointed counsel. So you're probably all familiar, at the state level, there's a public defender's office, which is the adversarial component to the district attorney's office. In the federal system, the chief federal prosecutor is the United States Attorney's Office. And so the public defender adversary to the United States Attorney's Office is the federal public defender. So the Middle District of Georgia, like most federal districts in this country, starting in 2007, had a federal public defender's office.
All right, now continue with your chronology.
So I was a federal defender from 2007 to 2009, and when I mentioned to you earlier, I had a second stint at Jones Court. In 2009, I left being a federal public defender and went back to Jones Cork and Miller, first of counsel and then a partner again in the firm. And so from 2009 until October of 2012, when I did what I knew I always wanted to do, probably in hindsight, I opened my own firm here. So I'm a sole practitioner. I have lawyers that work with me on a contract basis, but I'm a solo practitioner and have been since 2012.
Talk a little bit about being the federal public defender. Why did you choose that opportunity? And what was it that you liked about that role?
And my particular choice to do that is unique to my life experience. And candidly, yeah, I think if I had any of my former law partners here, they would continue to scratch their head and say, why did you leave a partnership in a big established civil firm to be a public defender? When I started practicing in Macon, the first 5 years you were a member of the Macon Bar, which if any of you choose to practice in Macon, you won't face this, unfortunately perhaps, but the first 5 years you were a member of the bar, you were required to take appointed indigent state criminal cases. And so as an associate at Jones Court, that was a requirement, and that's what I did. For me personally, that became a very rewarding practice. I mean, it wasn't financially rewarding, but it was important work for me. I saw the importance of good quality lawyers being in place to represent folks who couldn't afford to go hire a lawyer for themselves. So I had developed this particular interest in the importance of indigent criminal defense. But I also was starting this, what ultimately is large family we'll talk about. And so I had developed this desire to do indigent criminal defense, and then that coincided with the stage in my career when the Federal Public Defender's Office was opened. And one reality is that federal public defenders are paid much better than, unfortunately, state public defenders, and the benefits are better. So it was a correlation of what I had developed as a passion, plus the ability to do that in an environment where I could still support my family. So I was approached about helping open the office, and at that stage felt that that was a rewarding option and made the transition.
Students have heard me use this phrase before, but I'm from Texas, and sometimes we just throw a skunk on the table. All right?
Sure.
I want to throw a skunk on the table here because I want to hear your answer to this. As appointed counsel and as federal public defender, now in private practice, you have represented criminal defendants extensively. Okay. Some of those clients have actually done terrible things. Correct? Is that
Absolutely. Unless they'd all been acquitted, some of mine have been determined to have done.
And of course, your job is to do the best thing you can for them, despite, you know, and if you can get a guilty person, a factually guilty person acquitted, then that's your job, and you're going to do it.
Correct.
How can you sleep at night? That's the skunk.
Oh, sure, certainly. And look, that's a question you get. If you're going to do criminal defense, you're going to get that question, probably from some of your most beloved friends and family members, okay? First of all, every American citizen is truly presumptively innocent, okay? And so it doesn't matter to me factually, given my role as a criminal defense advocate, whether that individual is guilty, okay? And I will also tell you, we lawyers don't sit with a crystal ball or an advisor to us that tells us all the ramifications of what factual guilt or innocence is. So it's not my role to pass judgment on that individual. It's my role to make sure that even the guiltiest of the guilty are treated fairly in our system. Now that may look like making sure that an individual who acknowledges their guilt through a plea is then treated fairly and proportionately on their punishment, okay? And lawyers handle this differently. Some lawyers will intentionally never ask their client, did you do it or did you not do it? I'm going to look at the evidence presented by the government and I'm going to deconstruct and pick apart that evidence on the issue of the burden of proof. Some lawyers, and I fall usually into this category, I don't have any problem asking my client, because what my client tells me is privileged, whether they did it or didn't do it, because it doesn't change my approach. You may ask, well, why would you ask your client, did they do it or not do it? If they tell you, yeah, I'm guilty as the day is long, and does that somehow change your approach? No, because it's still my job to determine is can the prosecutor prove beyond a reasonable doubt their allegations, okay? And it's also not crystal clear because there are lots of layers in a criminal case, okay? The fact that somebody was factually present at a series of events that ends up getting them indicted doesn't necessarily mean they had, and I know you all are first year students talking about mens rea or whatever in criminal law, okay? That doesn't mean that the criteria are met for the mens rea or whether they knowingly, intentionally, recklessly, whatever did it. So there are hundreds of reasons why defense can be there even if your client comes. And I tell clients all the time, look, I know you have to develop a rapport with me and get to the point where you believe me on this, but it doesn't matter to me if you come in today and look me in the eye and say, I'm absolutely guilty. I did everything they say I did, okay? I will say, stop. It's my job as your lawyer to tell you this is what the law says. This is where the facts seem to lay down with what the law says. This is what the government says, okay? Now, these are your options, okay? I hope that answers.
No, I mean, that, as you say, I mean, that's a question that everybody who does criminal defense needs to be prepared to answer.
Absolutely.
Some of the students in this room will make a career out of criminal defense, and they need to hear that.
Right.
And those who don't need to respect the answer, even if they can't personally do it.
If any of you want to be prosecutors, and you know to your core you want to be prosecutors, you need to hear the same thing. And frankly, you need to take the same approach. Prosecutors need to look just as critically at who they're dealing with, who the individual is, even if factual guilt can be demonstrated. Is sending this person to prison for 15 years the best for them, society, whatever?
A lot of discretion.
Sure.
You mentioned that your goal all along had been to open your own laws.
Right. In hindsight.
In hindsight, all along it was your goal.
Well, in hindsight, I recognized that I was on a trajectory to have my own practice.
Talk a little bit about why that was or became your goal, given that you had any number of opportunities to practice in a different way. You know, why that?
It's a product of development as an individual, of recognizing how I was wired, recognizing how, I wanted my practice to go, how my practice was going, and how I best accomplished what I wanted to be as a lawyer. And what I mean by that is I benefited greatly from the structure of Jones Cork and being an insurance defense lawyer. Back to an earlier question, you know, one benefit of being an associate in a big firm, I had a steady salary. I never woke up thinking where the next file was coming from, and I had this structure to learn how to be a lawyer, okay? And I'm forever grateful for that. But I grew, and my practice grew. And this, I had no idea. Had you asked me in law school, are you going to be a prosecutor, are you going to be a criminal defense lawyer? I'm confident I would have said, there's no question I'll be a prosecutor, okay? So I didn't know that I was going to start at Jones Cork and that Macon was going to require indigent defense for 5 years and that I was going to develop this passion based on dealing with individuals. So I developed as a person, my practice developed where, I want to do criminal defense. And so part of the transition for me is Jones Cork has never done criminal defense. And this is not anything against the firm. They just didn't want to do criminal defense. They didn't hire lawyers or have lawyers that want to do criminal defense. So my practice had developed to where if I wanted to continue to do criminal defense, it was going to be challenging to stay at Jones Cork, or my practice would do better if I were somewhere else. And it wasn't just criminal defense. There were other areas of my practice. But so it's kind of a developing personal interest, developing realities of how you were going to grow that practice.
So the time comes you open your own shop.
Right.
What was the hardest thing at first about being your own boss?
Well, the hardest thing is my wife and I had 5 daughters at the time when I decided that I was going to take a complete and total leap of faith and open my own firm with no promises from no sector that I was going to succeed. I certainly at that point in my career had confidence that I knew how to be a lawyer, knew how to handle myself, and I had clients I had developed that I knew were coming with me to my new firm, some of them. But that was a huge leap of faith. You hear reward is proportional to risk, and that's right. Okay, I took an enormous amount of risk. I wasn't, and if any of my former law partners who are all my dear friends still, I wasn't going back to Jones Cork a 3rd time, okay? They'd say that, and that was just a reality, but I knew that I was taking a big risk, but I knew it was a risk that was ultimately going to allow me to control and develop the practice I wanted to do. And look, the economic realities are if you can succeed in that environment, you're going to do better financially. You're not taking a pie and splitting it by 25 parts. The economic realities are you're going to have 100% of what you generate.
Well, let's talk about that. There's a fair number of the students in this room eventually are going to have their own firms, communities of all different sizes. Were you prepared for the business side of that practice?
I was. And again,
most lawyers aren't. Law school doesn't do anything for you.
No, that's right. And many lawyers are not good business people, just like other professionals are. They may be great in whatever their chosen profession is, but they're terrible business people. So I would say, running your own firm is not for everyone. You need to be mindful that you have to be smart about the business side. But what's great about a law practice is you are the economic engine of that practice, okay? You are the reason the practice exists. The folks are coming to you. They need your advice. They need your expectation. So on the business side, if you're smart and you realize I don't have to grow until my capacity allows me to grow, okay? In other words, you'd be foolish to hang your shingle and go buy a building with 8 offices and 4 paralegal space and a great posh common area. That's silly. You can practice law out of your car. You can practice it out of your apartment, okay? And so you grow in conjunction with what your client base and the fees you're generating allow you to. And frankly, that happens even today. I have a successful practice. And I could go buy space and build a building tomorrow, but I don't want to allocate my resources or frankly take on that risk. I choose to rent space, and because I've got it in my budget and I know what my rent costs, and but I could do those things. It's just a matter of analyzing on a business basis what I want to do.
Well, talk about your practice today. What does it consist of, and is there a typical day for you? Help the students envision what it's like to be Brian Jarrard.
There are planned typical days. There are no typical days. I'll tell you my practice. I have a very general practice. My practice consists of plaintiff's personal injury, criminal defense, primarily federal criminal defense, but I also do state criminal defense, contested estate litigation, business litigation. I have done collection type materialman's lien work most of my career. So it's a varied practice. And the model I found that works, and I'd recommend this to any solo practitioner, I have a great mix of hourly paying clients and then contingent fee personal injury or retained criminal cases. And my business model is that hourly work allows me to cover the overhead and some, but I mean I could survive on the hourly work, but I'm able to do better financially based on this mix. And there's also safety in that because there are ebbs and flows in law practice. So there are times when my hourly files, because most of my files, I don't have institutional clients like an insurance company that's going to send me 100 files a year. I represent mostly individuals, and so these are, thankfully for them, one-time exposures to a discrete case. But that means then that my hourly work ebbs and flows. And big plaintiff's personal injury cases, for instance, folks that do just PI work, they have to, you're going to have a big recovery, but it may take you 3 years. So it's a budgeting issue. You know, you have a big recovery, then you got to understand you don't go out and buy a yacht. You have to budget that because that recovery is going to have to carry you for the next 3 years until the other big recovery. Okay, but you can appreciate then that if that's your only model, the risk is, okay, this was great. I got a $300,000 recovery, and I'm kind of banking on another $300,000 recovery in 3 years. But we all know in litigation that may not come. You know, you may miss, hopefully not, but you may miss through statute of limitations, or the law may change, or there may be some reason, you know, that your client told you wrong and the facts don't bear out, and you try the case and that jury gives you a goose egg. Okay, so if you've written a check on a $300,000 recovery that never comes, you got a problem.
Where do your clients come from?
I'm very fortunate. My entire practice has primarily consisted of referral from other lawyers. Now, I've been practicing long enough that I've had repeat clients, family, like in the PI context. I've had folks I've represented and they had a good recovery, and then their family member has a personal injury incident and they come back to their family lawyer. So it's been primarily referral. Frankly, I didn't have a website until last year. I know that's behind the curve, but
Yes.
Well behind the curve. And I'll tell you, I got a website because I got tired of clients saying, look, I looked for you on the web just to come see you or call you and didn't find you. So I do get some referrals or calls through the website, but most of my work continues to be from other lawyers and former clients. And one nuance that, you know, if you think about, many lawyers they hear federal court and run the other way. So I'm glad, I'm thankful for that dynamic. I benefit from somebody in a civil case, or particularly a criminal case, saying, oh, federal court, call Brian Jarrard. You know, the federal court's just another set of rules, and
Yeah, they're familiar with that.
Yeah.
At this point.
so
Do you have a favorite client or a favorite client story that you can tell the students to kind of give them a feel for where the joy comes from, other than just providing for your family and succeeding?
I do.
Financially.
I have lots of favorite clients, I guess. But I have a particularly rewarding case that I've been involved in, and I'll be continuing to be involved in at some level. But I have represented, this has actually developed into another practice area for me, but I've represented a developmentally disabled adult who was savagely beaten in a care home, and was, fortunately from the litigation context, it was all caught on video. And you say, well, why in the world is that rewarding? I mean, it's disheartening to see human nature and to see the abuse that that my client has undergone. But why it's rewarding is we were able to get a very significant recovery on behalf of this client. And I've been able, in conjunction now with a team, we created a trust for that client, and he has now a team of individuals, and I remain as his lawyer, as I'll continue to be his lawyer for the rest of his life, so long as his mother and family choose that to be the case. But why it's rewarding is now we got the weakest of the weak, who was savagely beaten, who now has a team of professionals across this state, so that I can say for him, okay, he will never be abused again, ever. And if somebody deigns to abuse him again, there are 10 of us that will be there in a heartbeat to make sure it ceases. So, I mean, that's rewarding stuff. I mean, that is, and it will, I'm sure, be one of the most rewarding parts of my career from now until I retire.
His life is different because of you.
Yep. That's both a very daunting challenge, and I'm glad you say it that way, because, look, being a lawyer is an honorable thing, and I don't want you to ever let anybody tell you differently and believe it, okay? We have the privilege of being the voice for people who either are not trained to speak for themselves or who literally cannot speak for themselves. And that is one, both what keeps me up at night, but it is one of the most wonderful things about why you're here, okay? Why you're studying so hard. I know you got an exam today, okay? It's why you're doing those things, okay? Because one day you will be able, just like me, to sit up here and tell a group of first-year law students, hey, there's this individual who I can take you to today, and we can sit down with him, and his life is better now and for the rest of his days because I was in it.
It's always important to remember why.
Yeah. And remember why you came to law school.
Yeah, that too. There was another part, if I remember right, that was this case, that was kind of a more day-to-day mundane lesson about making sure you meet deadlines. Was that this case?
Yep.
Yeah. Can you tell that part of the story?
Sure. You know, part of being an advocate, particularly a trial lawyer, is, and I think one of the questions that I've been asked before is about taking advantage of options that you get presented to you by either the incompetence or of another lawyer. Okay.
Good timing. We've been talking about that this week.
Let's talk about it. Okay. Deadlines mean something. Particularly deadlines mean something in litigation context. Okay. So in this case, we were able to take a liability judgment because a deadline got missed, okay? Because, of course, the defending parties didn't have anything good to say, so they might as well have missed the deadline. But they missed a deadline in responding to our complaint, okay? And so late on a Friday afternoon, after multiple extensions from me, because I will tell you this on the professionalism side, my rule, and most every lawyer you deal with, I give extensions liberally. That's a lawyer call, okay? So if a lawyer needs another 30 days to respond to a complaint, I'm going to give it to the lawyer, okay? If a lawyer needs more time to respond to discovery, it's a foregone conclusion. I'm going to give it to the lawyer unless they've already defaulted and it somehow would prejudice my client, okay? But in this case, I had given multiple extensions, and then late on a Friday afternoon when the deadline was to answer the suit, the lawyer puts his client in the car with the answer and tells the client to drive down to court and file it. Well, the story I get told is the client got caught in traffic and didn't make it. And I'm like, well, I'm sorry, okay? It's not my job to answer your lawsuit on time, particularly in these facts. And so, yeah, I heard, you know, you get deadlines around here about file things at certain times. Well, they mean things, and they mean things in law school, and they mean things in law practice. In law practice, they may mean notifying your errors and omissions carrier that you missed a deadline. So, absolutely, those are important things, and those are also things that keep you up at night.
You mentioned dealing with other lawyers, and one of the things we talk about in this class is civility and its opposite. I think I know the answer to this question, but I want to hear the elaboration. Have you ever encountered a lawyer who conducted himself or herself in an unprofessional way? And do you have an idea of why they would do it? And how did you do it?
The answer is yes. The answer also is, fortunately, that has been very rare in my now 18, going on 18 years of law practice. I would say 99% of the lawyers you deal with are going to be consummate professionals, but there are individuals who we've dealt with who, my view is, their personal life was probably in shambles. I mean, I wasn't privy to that, but they were just miserable people, and they didn't know any other way to conduct themselves personally, so it bleeds over into law practice. And look, I've encountered lawyers who think wrongly that the best way to be an advocate is just to be a jerk at every level, to internalize. Look, you're going to have clients who cannot stand the opposing lawyer, okay? And I tell clients all the time, look, the opposing lawyer is an advocate for your opposition, okay? So you shouldn't internalize the stress of your team, even with the opposing party, okay? I mean, there are times, I do contested estate fights, okay? There are times when, I mean, frankly, these family, they hate each other, okay? And I digress, but sometimes in estate fights, the hatred has nothing to do with the legal issues you're fighting about, okay? It has to do with some old grudge from 20 years ago, you know, mama liked me better, or whatever. And here's what's frustrating from the lawyer's perspective. I can't control that, okay? I mean, I can't go back and unwind 20 years of dysfunction. And the reason, so I digress talking about estates, but yeah, there are times when the lawyer has to remind everybody in the room, look, I wish the best for all of you. I've got to be an advocate, and I'm here to be an advocate for my client, okay? But that doesn't mean I dislike you personally, okay? I may dislike and disagree with your choices, and I'm going to advocate for my client. But there are some lawyers I've encountered who don't even appreciate that themselves, okay? So that their client dislikes me because I'm advancing a position contrary to them, okay? So then the lawyer dislikes me. And I'm like, look, I don't have, you know, it's fine. I've got a role to play, and I'm going to play that role. But I don't dislike you, and there's no reason for you to dislike me. And let me pull back in all seriousness and say, hey, lawyer, we do a better job for our clients when you and I get along, okay? We're here to help these individuals solve a problem within the bounds of the law, okay? We're going to be better at helping them solve the problem if you and I can talk rationally, okay? And I've had estate fights where I've said to my client, I'm telling you, I'm going to sit down with the other lawyer, and we're going to talk about how to solve y'all's problems, and I don't want any of y'all there, okay? Now, it's all going to be with your permission. No case is going to get settled because you're the client and you get to, but you all need us to sit down and talk through this. Now, I'll say another thing on the professionalism side, though. It's rare then to run into the lawyers who you just can't get anything done because they're just jerks, okay? And they're not going to be professional to you. They're not going to agree to any extensions. But a more nuanced professionalism issue, as I see it, is I run into otherwise very good lawyers who I think get lost in the difference between what's best for my client in the big picture, okay? And here's an example, okay? Yeah, you can, and your client's fired up and your client's trusting you and your client's going to do whatever you tell your client because they have to trust you. But why do you tell a client to spend $100,000 on a lawyer for a best case $80,000 resolution? Okay? If you're just talking money in a civil case, okay? I think lawyers constantly have to say, I've got to check at the door to make sure I'm giving this client solid advice, okay? And I tell clients all the time, I get calls about, you know, somebody owes me $5,000, okay? And then they want to tell me all the different ramifications of this is why I'm right, but this is what they say, okay? All right. And so, sir or ma'am, you're going to pay this law firm $15,000 to get to a $5,000 resolution. So my advice to you is either try to work it out or let it go. So I do think that's a bigger professionalism issue from otherwise very good lawyers.
Before we lose the chance to do it, I want you to talk about your family.
Okay.
And how you balance running your own practice with your family also.
Of course, I'm happy to talk about the family. We can spend all hour doing that. But so I mentioned earlier, let me tell you the story of my wife and I. We were college sweethearts, met at Georgia Southern, married, in fact, before we finished Southern. But we have 5 biological daughters and then 3 adopted sons. So we have 8 children. We had a 5-year-old daughter, we had a 4-year-old daughter, and then our 3rd pregnancy turned out to be our 3rd, 4th, and 5th daughters. Okay, so we have natural spontaneous triplets. So I was a young lawyer.
That'll age you quickly.
Yeah, I was a chronologically young lawyer who had 5 daughters at 5 and under. Okay, but again, we're very fortunate. My wife and I decided our family still wasn't complete. So after our biological daughters, we have adopted 3 little boys. They're all of Chinese descent, and they all have Down syndrome. And so our boys are 7, 5, and 3. So yeah, not to beat my chest and brag, but I can talk about work-life balance. So, first of all, choose your spouse wisely. Okay, choose somebody who is aligned with you at every level as far as what you want life to be, supportive of your career, supportive of where your career fits in the overall dynamic of the family. And I thought about this because I know I've been here before. Okay, this work-life balance issue comes up. Okay, here's the first thing as I've thought about it the last few days. Okay, I suspect if I were to take a poll of you all today, when you're thinking work-life balance, you're thinking, how do I make sure I'm the absolute best lawyer I can be, and then fit in the life I want to have away from the law? Okay? That totally turns it on its head. Okay? My view is you all need to focus on being the best person you can be, whatever that looks like for you. Okay? And then being a good lawyer will follow that. Okay? What I mean by that is, look, focus on stuff like, how do I treat other people with dignity? How do I ensure that even if somebody is very different from me in worldview, religion, life experience, how they choose to deal with me or others, okay? If I focus on being a good person first, I'm going to be a good lawyer, okay? And you say, well, yeah, that sounds great, but how is that true, okay? If I understand that dealing with somebody whose life choices are diametrically opposed to my own, whatever they are, okay, but showing that person respect and dignity, all right? How does that not bleed over into law practice? I'm in an adversarial role. I deal with people every day who have made life choices, criminal defense, okay? They've made life choices to use heroin, rob a bank, whatever, okay, that I don't agree with. But I meet them where they are, okay, and say, all right, how do we figure out what you've done, deal with where you are, and deal with where you should be, okay? All right? That doesn't come from being a lawyer. That comes from being a decent person. So now, there's time management. You guys are learning time management now, okay? I mean, if I ask you to raise your hand, how many have that gnawing sense in the back of your head while you're listening to Brian Jarrard? I got an exam this afternoon. Okay? Yeah, right? Everybody, you're not going to offend me. You raise your hand. All right? That gnawing sense of, yeah, I'm trying to plug in and listen to Brian Jarrard, but I really need to be thinking about so-and-so. Okay? That's good preparation for law practice. Okay? I have the luxury as a sole practitioner. I can come and go as I please. So I leave during the day. My staff, bless them, they understand. I may walk out the door at 10:30 and say, I'm headed down to see Professor Long at law school, or I'm headed home to run an errand, okay? And I'll be back when I get back. But I also have deadlines. I have briefs to be filed. I have court appearances, okay? So it's constant juggling of deadlines, but it's just a product of making sure that you get it all in. It's also a product of saying no. I mean, you got to know your limitations. You got to know that this is how much I can do, and this is how much I can do well, and I need to confine myself to that, and I need to have the wisdom, which I'm telling you to do as I say, not as I always do very well, okay? You need to have the wisdom to say, you know, I can do that, but I don't need to do that.
Choose not to. Yeah. Let me turn it over to the students. What questions do you have for Jarrard? Cannot have anything to do with legal research. I know you want it to. But. Yes, ma'am.
You talk about balancing your family life with your solo practitioner business. What about when you were in a firm? Did you find that more challenging? Did you find that a reason as to why you left the firm was because maybe you didn't have as much freedom? Or what was your experience with your family life and your firm?
Great question. Did everybody hear the question? Okay. First of all, I was very fortunate at Jones Cork, okay? Jones Cork is a family-oriented firm, okay? So I got told day one as an associate in that firm, we value family, okay? We work hard, okay? But we value family. And so I never had what you might view as the typical big firm, you know, you be here 20 hours a day and then go home and, you know, catch a bite to eat and say hey to your kids, go to bed and be back here tomorrow, okay? But there's always going to be a tension even in a firm that has that view that, well, I'd like to go to my child's ballet recital, but I got a brief due. And part of that is, well, understand, look ahead. You know, my child's ballet recital didn't pop up overnight, so you know it's coming in a month from now, and you know you also got a brief that's due the day before. Well, then start on your brief before 3 days before. And that's easier said than done sometimes, but it's manageable, okay? None of that, though, pushed me to make the transition. I made the transition. Well, I say that. That's not accurate. There certainly is a benefit to being self-employed. Just like I mentioned, I come and go as I please, okay? That's great. If I know the bills are going to get paid and I can come and go as I please, you know, I mean, that's a wonderful autonomy. And certainly I didn't have that autonomy in a firm, not just firm imposed. I didn't have it because I self-imposed it. It's like I thought, man, it's a great spring day. I'd love to leave at 2 o'clock today and go hang out with my kids. Well, if I walked down the hall and every other partner in the firm sitting there going hard at it, I felt this guilt about why would you do that, okay? It's self-regulation when you're your own employer. I mean, I could take the next month off if I wanted to, but I'm not going to generate any income. So now, if I'm not working, I'm not making any money. So it gets regulated for different reasons now. Okay.
Other questions?
Okay, this young lady.
Yep. Sorry.
So you spoke a little bit about when you started about how you could walk down the hall and ask other partners questions.
Right.
What do you think, since a lot of us are going to have summer jobs this summer, what do you think are good questions to ask when we get just a stack of papers?
That's great. And look, if you don't get this guidance, like in a memo about an assignment, these are questions to ask. I mean, first of all, you got to make sure you understand the assignment, okay? And don't be paralyzed by fear, okay? Don't be afraid to ask questions. If you read an assignment and it talks about, I don't know, the rule against perpetuities, let's say that, okay? You know, you get some rule, I don't understand, I didn't understand law school, I don't understand the rule against perpetuities today. So if you get and you're not going to get an assignment as a first-year lawyer on the rule of perpetuities, I'm just using that as an extreme example, okay? But if you get a memo from a partner that says, I want you to do so-and-so, and it's like it's written in Greek, you know, I have no idea what this has to do with, then first of all, yeah, you want to ask questions and don't be paralyzed by fear. Ask questions that frame what you're there to be doing, okay? Because the worst thing would be to just say, oh, I don't want to embarrass myself, and so I'm not going to ask any questions. Well, but you're not gonna make any progress, and at the end of the day, the partner's gonna look at you like, did you tackle my assignment? Make sure you understand the assignment. Sometimes you're gonna have to elicit, for busy lawyers, and my folks that work with me now would say, they have to like literally sometimes grab me and say, tell me precisely when you want this done, okay? Because you've told me 50 things you need me to do. So you got to prioritize for me. I can't read your mind, okay? So don't be afraid to say to that person, when do you want this done? Okay, is this something I need to have you an answer by the end of the day? Is this an all summer assignment? Okay. And then once you know the ground rules though, you spend the time to flesh out that assignment in a way that you're proud of, and it's going to be fine on the back end. Okay. Again, remember my advice. You're getting those assignments. Certainly the lawyers as a first-year law student, the first summer, that lawyer can get that answer for themselves in 10 minutes probably. Okay? So I'm not belittling it. We've all been there. Okay? They're giving you that assignment for your benefit. Okay? I'll tell you this, one of my dearest friends in the law came when I was an associate one time. I was probably doing too good of a job of following my own advice to you. He gave me an assignment. I was digging in, I was looking at the cases, but like at every turn, every nuance, I was going back into his office saying, hey, I found this. You know, what do you think about so-and-so? Okay? And at some point, he's a busy lawyer. You know, he wraps his arm around me, walks me into the library at Jones Court, and says, Brian, the answer to all of your questions are in these books. Okay? And look, I took that for example, and I've told other young lawyers that now, okay? The point was, look, you helped me by not coming to ask me these questions, okay? You helped me by digging in, making these judgment calls yourself. Is this case applicable? Is it not applicable? Can I distinguish it? The things your wonderful professors are teaching you day in and day out, okay? Well, do you blindly accept this proposition in a case, or do you challenge it, and why is it wrong, okay? You do all that, and then you give a product back to that partner, okay? And I think we started this discussion. How do you succeed at a big law firm as an associate? And it's going to take 2-3 assignments, and those partners are going to know you fit this mold, okay? If you get to the point where you take an assignment back to a partner and that partner doesn't have to be hesitant at all, that they can say, I know this person, I know they looked under every stone, and this is the answer, and I can pick it up and move forward, you're going to be successful.
Well, can you stick around for a few minutes and chat? Well, join me in thanking Brian Jarrard.